My name is Brad Willingham, and I will be doing a case study presentation over Mossner versus Atlantic City Country Club for EDU 503, which is a sports law class at William Woods University. The issue raised in this case is whether golf course operators owe a duty of care to their patrons to protect them from lightning strikes. The plaintiff in this case is Spencer Mossner, and the plaintiffs are appealing the judgment that was given as a summary judgment to the defendants. The Mossners think that the trial court was wrong to conclude that the owners and the operators of golf courses should not have to protect them from lightning strikes. In the Mossners' opinion, is that the lightning strikes on a golf course are a foreseeable risk that must be addressed by owners of the golf course. The plaintiffs, which is the Mossners, maintain that their case was dismissed way too early before they could figure out who was responsible for failing to have proper safety procedures in place at the golf club. The appellate court found that there was enough information brought up by the Mossners that it warranted a trial to see if the Atlantic City Country Club did properly implement those safety procedures. This incident occurred Sunday, March 28th, 1993. Around 7:30 a.m., Spencer Mossner arrived at the club with his friends Michael Mahue, Robert Dews, and Peter Costanzo. And a snowstorm had been predicted that morning, but Mossner and his friends continued to make their tee time to play that day anyway. It was overcast that morning. It was drizzling rain when they began to play. And while they were playing their first two holes, the drizzle turned into a downpour, then slowed down by the time they got to their third hole. While they were there at the third hole, they noticed it was starting to have lightning strike, and they went along the inside of the fairway intending to seek shelter back at the clubhouse. Now, on this golf course, there are no man-made structures or shelters, and at this time, Mossner put up his umbrella to keep from getting wet because it was raining pretty good. And McHugh and Dews were about 15 yards behind him. And McHugh saw Mossner get hit by a bolt of lightning, which is what he got substantial injuries from. Dews went, at that time, Dews went for help at the clubhouse, and a caddy that was with them or nearby was sent to a nearby police station to get more assistance. McHugh started CPR to Mossner until the police and the medics arrived. And McHugh stated that the club caddy master and the club pro arrived to the scene the same time as the police did. And at that time, lightning was still appearing in the sky when the police arrived and the medics arrived. At this point, after this happened, Mossner filed a complaint seeking damages for the injuries that he sustained at the golf course. The defendants, which is Atlantic City Country Club and those owners that are involved in that, maintain that they are under no duty to protect people from lightning strikes, and that Mossner's injuries, even though they weren't life, they didn't kill him basically, were the result of an act of God. The defendants also moved that the plaintiff did not prove that they had created or maintained dangerous conditions on the golf course. The defense also stated that they used reasonable care to make their golf course safe by monitoring the Weather Channel, and that signs were posted at the country club instructing members of their evacuation plans and what to do if inclement weather did happen while someone was playing golf there. As part of the defense's evacuation plans, they would basically have the golf pro and the pro shop manager drive around on golf carts and warn people and tell people to seek shelter and get back to the clubhouse. The club admitted at the time, and they still don't, to not possessing any equipment for detecting lightning or having any audible warning devices or any shelters or lightning-proof shelters on the course. The defense also maintained the club members were warned about general risk of lightning by the club golf pro and a United States Golf Association poster, which both were posted in the locker room. They didn't actually talk to a golf pro. He had written up a sign and put it in the locker room. The act of retrieving the golfers at first sight of lightning has been one of the things that they had in place for about 40 years. And the plan also mentions that they encourage golfers to retreat to nearby private homes that usually surround golf courses in the event of severe storms. The defense also claimed that one of the caddies did make this suggestion when the Mosner and his friends were heading back to the clubhouse, that they could seek shelter at one of these homes. Now, the plaintiff claimed that the posters were not in place in the locker rooms until after he was struck by lightning, and that there's now technology out there for the golf course to buy that makes lightning's presence more predictable, and that the golf course should have bought some of those devices. Now, in the end, the courts have found that lightning strikes are so highly unpredictable of where and when they strike that they said that the risk to be guarded against is too remote to impose legal liability. The court also state that golf courses do owe a general duty to protect their patrons, but not to all potential harms. Like, for instance, if you were walking along and you trip over your own golf bag, that injury should not be the problem of the golf course because you tripped over your golf bag. The act of God defense didn't free the defendant from blame and they tried to use that defense. The defense tried to use this to help their case by saying that they didn't do anything or build any structure that would make a golfer more prone to be hit by lightning. So if they did get hit by lightning, it was an act of God and not because of something that they did to put the golfer in harm's way. The courts decided all golf courses need to have signs that detail what safety procedures they have in place. And if no safety procedures are being used, then they need to have signs up stating play at your own risk. If golf courses choose to build shelters, they have to have lightning-proof shelters. If they're going to have siren systems, the golfers must be able to hear the signal from where they're playing and know what those signals mean. So basically, having horns and sirens going off, if the golfers do not know what those horns mean, they really are pointless. The courts also decided that they can't mandate that these items be used because it might be cost prohibitive for some golf courses to buy. Many golf courses today are holding on by a string and are having a hard time making a profit nowadays. So now, when it comes to the aspects of what a athletic director of a school district needs to do, when it comes to safety of their student athletes, basically it's their students are playing at a privately owned golf course, and many times these sporting events do not happen at competing school campuses. The liability insurances issues that come with that or might occur wouldn't be an issue normally during a gameplay on school campuses like for other school sporting events. So golf is kind of a different thing where you're actually going and playing on other people's property. Athletic directors need to communicate with the coaching staff, I believe. These issues and how to deal with these whenever these complications arise need to be something that's dealt with from the athletic director with the coach. Also, the coaching staff should be aware of the school's evacuation plans and also what the different courses and golf courses, what their evacuation plans are, or even if they even have an evacuation plan. The golf course owners or general managers need to communicate with the coaches that are using their facilities of any inclement weather that might be arriving. And by the way, the coaches themselves should know the weather report ahead of time as well, because they shouldn't just be relying on the staff at a golf course. With the technology we have today, everyone should be able to get online or check the weather before you get on the bus and head to a different golf course. Many times with school golf, and that's another thing, some preventative measures for lightning and bad weather that occur with outdoor sports like football, soccer, other outdoor sports need to be implemented to the golf team as well. Many times with school golf, that's another thing. It's not a large spectator sport. This means that most parents aren't at these golf events, mainly because it's not easy to follow around their child from hole to hole and watch them. So parents need to be in the loop with the weather conditions, and sometimes their child might be several hours away competing in weather that's totally different than what's in their hometown. This isn't a big problem, but I think that there needs to be a way that the coaches or the athletic administrators can communicate quickly with the parents via Facebook, or having an all-call system that goes out to all the golf athletes' parents so they know what the actual weather conditions are at that particular golf course. This concludes my presentation on case number 3.3. Thanks.